In theory, the UK Parliament possesses absolute legislative sovereignty. It can write or repeal any law it chooses. Yet when the executive branch attempts to enforce stringent border controls or enact mandatory minimum sentences, those actions are routinely blocked by the courts. Historically, the UK operated on a strict dualist model. International treaties had no direct effect on domestic law unless explicitly written into the statute books. Today, executive action has to pass through a highly complex judicial filtration net. That net is the Human Rights Act of 1998. It took the rights outlined in the European Convention on Human Rights, the ECHR, and embedded them directly into domestic UK law. The ECHR functions as a hard, structural legal bottleneck. It forces civil servants, ministers, and judges to weigh every significant public decision against a strict web of individual rights. Restoring absolute parliamentary sovereignty requires removing the legal mechanism enforcing this constraint. Exiting the ECHR is the prerequisite for achieving unmitigated executive control. Until this hurdle is cleared, aggressive primary legislation will remain inherently subservient to supranational proportionality tests. Operating a stringent borders policy, one that detains and rapidly removes illegal arrivals at scale, is legally impossible under the current framework. Mechanistic or blanket category-based deportations fail because the law demands individualized judicial assessments. We saw this policy blockade materialize during the Rwanda litigation. The government's plan to offshore asylum processing was dismantled in the courts, ultimately blocked by the Supreme Court based on specific ECHR provisions. Courts apply Article 3 to prevent removal if there's any theoretical risk of return to a dangerous territory. Article 8 overrides deportations for foreign offenders with strong domestic ties. Finally, a Rule 39 interim measure from Strasbourg can halt flights minutes before takeoff. Because these articles exist in domestic law, the state cannot process migrants as a collective bloc. Every single person is entitled to an individualized judicial assessment of how deportation affects their specific rights. The requirement for individualized assessment has turned border enforcement into an endless balancing act between state policy and personal rights. This same legal architecture extends inward, restricting how the state manages domestic security, criminal sentencing, and public order. A government cannot enact strictly applied mandatory minimum sentences for repeat offenders. Stripping away all judicial discretion and eliminating any prospect of release violates human rights commitments. In the Venables case, the European Court of Human Rights ruled that indeterminate sentences for minors only remain compatible with the Convention if they include tailored reviews. Parole mechanisms and minimum tariffs act as legally mandated escape valves to prevent a sentence from becoming disproportionate. Managing disruptive protests operates under similar constraints. Following the Supreme Court's ruling in DPP v. Ziegler, prosecuting protesters for blocking a highway requires police and courts to apply a strict proportionality test. They must weigh the disruption caused against the democratic value of the protest. Look at the political debate surrounding the 2026 Al-Quds Day demonstrations in London. The police faced a scenario with multiple competing marches and a high potential for serious public disorder. The Home Secretary invoked Section 13 of the Public Order Act, authorizing a specific prohibition on moving processions for that particular event to keep the public safe. But under Articles 10 and 11, which protect freedom of expression and assembly, that prohibition could only go so far. Static protests could not be banned. The police had to accommodate them and could only impose conditions on timing and location. The law demands that the state facilitate the right to protest. Parliament cannot introduce outright, blanket bans on disruptive demonstrations without violating these convention rights. By requiring courts to constantly evaluate proportionality, the ECHR effectively outlaws zero-tolerance law enforcement strategies. The state is legally forced to tolerate a certain baseline of disruption to satisfy human rights criteria. How did these specific limitations on executive power become so deeply embedded in domestic UK law? Section 3 of the Human Rights Act 1998 requires UK judges to interpret all legislation as compatible with ECHR rights. If impossible, Section 4 empowers courts to issue a declaration of incompatibility, acting as a massive political roadblock against the state. This domestic framework is tethered to decisions made in Strasbourg by the European Court of Human Rights. That court operates on the living instrument doctrine. They interpret the convention not by what the text literally meant in 1950, but by what they believe it requires in the context of present-day conditions. This approach continuously expands the scope of rights far beyond the original intentions of the post-war signatories. It creates a dynamic environment where UK courts are statutorily bound to unpredictable, ever-widening rulings from a supranational body. The Human Rights Act rewires the constitutional hierarchy, subordinating domestic statutory intent to evolving international case law. Critics of withdrawal point out that the ECHR is not the only treaty governing these issues. Does leaving it actually matter if the UK is still a signatory to other agreements? Even entirely outside the ECHR, the UK remains bound by the UN Convention Against Torture and the 1951 Refugee Convention. These instruments still mandate non-refoulement and prohibit returning asylum seekers to danger. To understand why the ECHR is uniquely restrictive, we can compare the UK to Australia. Both nations are signatories to the 1951 Refugee Convention. Only the UK is subject to the ECHR and its enforcement body, the Strasbourg Court. Australia has successfully implemented highly stringent border policies, including extensive offshore processing and strict maritime turnarounds, while maintaining that it is fully compliant with the Refugee Convention. The critical variable is the enforceability gap. The Refugee Convention lacks a standing interpretative body. There is no supranational court with the authority to issue binding judgments on how its text must be applied. Without a court empowered to hand down emergency injunctions or mandate proportionality tests, the sovereign state determines its own legal compliance. Executive actions are not subjected to an endless cycle of international judicial review. Withdrawing from the ECHR does carry collateral legal complexities. For instance, the Trade and Cooperation Agreement with the EU contains specific termination clauses regarding criminal justice cooperation if a party denounces the convention. There are also highly contested challenges surrounding the Good Friday Agreement. That peace settlement explicitly references the ECHR as an enforceable safeguard against the abuse of power by devolved public bodies in Northern Ireland. But purely as a mechanism for domestic governance, exiting the ECHR does not erase international norms. Instead, it exploits the enforceability gap, allowing lawmakers to bypass judicial blockades and fully restore domestic executive power. The European Convention on Human Rights is not a passive declaration of values. Embedded in domestic law, it acts as an active, structural constraint on state power. This legal architecture deliberately preempts mechanistic border enforcement. It prevents inflexible mandatory sentencing and stops police from executing absolute bans on disruptive public order events. Restoring strict executive enforcement requires removing that jurisprudential filtration net entirely. Attempting to solve these bottlenecks by passing targeted, piecemeal domestic legislation rarely succeeds. Crafting laws that attempt to bypass convention rights simply invites further litigation and formal declarations of incompatibility from the judiciary. As long as the Human Rights Act remains on the statute books, domestic judges are legally bound to apply proportionality tests, continually frustrating executive objectives. Withdrawing from the ECHR is a necessity for lawmakers seeking unmitigated authority over borders and justice. Eliminating the proportionality test and removing the jurisdiction of Strasbourg is the only structural path available to fully restore the strict dualist tradition of parliamentary sovereignty.